The Central Bureau of Investigation, or CBI, plays a crucial role in investigating high-profile and complex cases in India. However, its jurisdiction often becomes a point of contention, particularly when operating within the territory of a state. The CBI's authority to investigate cases in a state is not inherent. It requires consent from the concerned state government. This requirement stems from the federal structure of India, which divides powers between the central government and the states. The legal framework governing the CBI's jurisdiction is primarily found in the Delhi Special Police Establishment Act, 1946. This act lays down the circumstances under which the CBI can exercise its powers of investigation. Understanding the provisions of this act, specifically Section 5 and Section 6, is crucial to comprehending the jurisdictional complexities surrounding the CBI. The delicate balance between the center and the states, as enshrined in the Constitution, forms the backdrop against which the CBI's operational authority must be viewed. This essay delves into the legal intricacies surrounding the High Court's power to direct CBI investigations within a state's territory without obtaining prior consent from the state government. The essay will explore the relevant constitutional provisions, analyze landmark judgments, and discuss the implications of such judicial directives. By examining the legal precedents and the principles underlying them, the essay aims to shed light on this complex issue and highlight the need for a balanced approach that respects both judicial review and the federal structure of India. The Delhi Special Police Establishment Act, 1946, forms the bedrock of the CBI's investigative powers. Section 5 of the Act deals specifically with the CBI's jurisdiction within Union territories. It grants the CBI the power to investigate offenses in Union territories without requiring any specific consent. However, the scenario changes when it comes to states. Section 6 of the Act lays down the procedure for the CBI to exercise its powers in states. It mandates that the CBI can investigate a case in a state only with the consent of that state government. This provision is a clear reflection of the federal principle enshrined in the Indian Constitution, which recognizes the autonomy of states within their sphere. The requirement of state consent under Section 6 has been a subject of much debate. Proponents argue that it safeguards the federal structure and prevents the CBI, which is under the control of the central government, from being misused against state governments. Critics, however, contend that it hinders effective investigation, as state governments may be reluctant to allow an independent agency to probe matters that could potentially expose their own wrongdoings. This difference in the CBI's powers in Union territories and states stems from the constitutional distinction between the two. While the central government has wider powers in Union territories, it exercises power in states through a framework of cooperative federalism, necessitating consent and coordination. The Indian Constitution, under Articles 226 and 32, empowers high courts and the Supreme Court, respectively, to issue writs for the enforcement of fundamental rights. These articles are cornerstones of judicial review in India, allowing courts to scrutinize the actions of both the central and state governments. Article 226 empowers high courts to issue writs to any person or authority within their jurisdiction. This broad power allows high courts to direct CBI investigations even within states, bypassing the requirement of consent under Section 6 of the Delhi Special Police Establishment Act. High courts have often invoked this power in cases where they deem it necessary to ensure a fair and impartial investigation, especially when there are allegations of state complicity or police inaction. Similarly, Article 32 vests the Supreme Court with the power to issue writs for the enforcement of fundamental rights. While Article 32 is primarily invoked for violations by the central government, the Supreme Court can also intervene in cases where a high court's order directing a CBI investigation is challenged. The power vested in the high courts and the Supreme Court under these articles is not absolute and is subject to judicial review. The courts have, over time, laid down certain principles and considerations that guide them in exercising this power. The case of Abdul Rahman Munal, a Kashmiri Pandit social worker, exemplifies the circumstances under which high courts have exercised their power to direct CBI investigations without state consent. In 1999, Munal was brutally attacked, and the subsequent investigation by the local police was widely perceived as lackluster and biased. The attack on Benagal sparked outrage, leading to public demands for a fair and impartial investigation. The Jammu and Kashmir High Court, taking cognizance of the matter, transferred the investigation to the CBI, despite the lack of consent from the state government. The court justified its decision on the grounds that the local police had failed to conduct a proper investigation, and there were serious doubts about their impartiality. This landmark judgment underscored the High Court's power to intervene in cases where there is a credible apprehension of bias or lack of fairness in the investigation conducted by the state police. The court emphasized that the right to a fair investigation is an integral part of the right to life guaranteed under Article 21 of the Constitution. The Benagal case set a precedent for judicial intervention in cases where the integrity of the state police is called into question, and the need for an independent investigation is paramount.